FELA Statute of Limitations. How long do I have to file a railroad worker injury lawsuit? The FELA Statute of Limitations is a critical factor in determining whether an injured railroad worker can file a claim for compensation. This legal deadline limits the amount of time you have to take action after a workplace injury or illness occurs. This video will help you to better understand the FELA Statute of Limitations. However, each case is unique, and it is best to contact an FELA lawyer to get a free case consultation to confirm your statute of limitations. The figures outlined in this video are generalized and should not be taken as a guarantee of your SOL timeline. Contact Gianaris Law Firm for a free consultation. FELA Statute of Limitations. The Federal Employers Liability Act provides a legal avenue for injured railroad employees to seek compensation when their injuries result from their railroad employer's negligence. Unlike traditional workers' compensation systems, FELA requires the injured worker to prove negligence on the part of the employer. A critical aspect of filing an FELA claim is adhering to the statute of limitations, which sets a deadline for initiating legal action. Under FELA, an injured railroad worker has 3 years from the date of the injury to file a lawsuit. In cases involving occupational diseases or injuries that develop over time, such as cancer from toxic exposure, the 3-year period begins when the worker knew or should have known that the illness was work-related. This discovery rule accounts for the latency period of certain conditions, ensuring that workers have a fair opportunity to pursue claims even if symptoms do not appear until years after exposure. Failing to file within this 3-year window can result in the loss of the right to seek compensation, regardless of the injury's severity or the employer's level of negligence. Given the challenges involved in determining the start of the limitations period, especially in cases of long-term exposure or delayed diagnosis, it's crucial for injured workers or their families to consult with an experienced FELA attorney promptly. Understanding and adhering to the FELA Statute of Limitations is crucial for protecting your rights and securing the compensation you are entitled to. If you or a loved one was injured while working for a railroad or later developed an illness linked to that work, you may have up to 3 years to file a claim under the Federal Employers Liability Act. Points to consider regarding the FELA Statute of Limitations. 3-year time limit. The claim must be filed within 3 years of the date of the accident or discovery of a work-related illness. Discovery rule. In cases involving toxic exposure or cumulative trauma, the time limit begins when the worker knew or should have known the condition was work-related. Wrongful death claims. A personal representative must bring the claim within 3 years of the date the worker was killed. Contributory negligence considered. FELA reduces compensation in proportion to the injured worker's own role in the incident, but does not eliminate recovery. Negligence attributable to the railroad. The plaintiff must show that negligence attributable to the railroad employer contributed, even slightly, to the injury. Filed in federal court or state court, depending on strategic preference and jurisdiction, claims may be filed in either venue. Covers physical and occupational illnesses. Injuries may arise from defective equipment, poor working conditions, or exposure to toxic substances. Failing to file within the specified time frame can result in the loss of the right to seek compensation. It's imperative for injured railroad workers or their families to act promptly and seek legal counsel to protect their rights under this federal law. When does the FELA Statute of Limitations begin? Under the Federal Employers Liability Act, the standard statute of limitations is 3 years. However, the exact commencement of this period depends on the nature of the injury or illness. For injuries caused by a single traumatic event, such as a derailment, fall, or equipment failure, the 3-year clock typically starts on the date the accident occurred. In these cases, the injury is immediate and apparent, and the filing deadline is straightforward. However, for occupational diseases or cumulative trauma, such as lung cancer from diesel exhaust, mesothelioma from asbestos, or repetitive stress injuries, the start of the limitations period is governed by what's known as the discovery rule. This means the 3 years begin when the worker knew or reasonably should have known that their condition was related to their railroad employment. For example, if a former railroad worker is diagnosed with kidney cancer in 2024 and medical evidence links the cancer to long-term benzene exposure during their career, the statute of limitations would begin at the point of diagnosis, not when the exposure originally occurred. This flexibility helps protect workers who suffer from illnesses with long latency periods, which may not manifest symptoms until years after exposure has ended. It's important to note, however, that courts will assess what a reasonable person in the worker's position would have known, so delays in seeking medical attention or ignoring symptoms can complicate claims. Determining the exact starting point of an FELA statute of limitations requires a fact-specific analysis. If you're unsure when your claim period began, or if a deceased loved one may have been affected, it is essential to speak with an FELA attorney immediately to protect your right to recovery. Consequences of missing the FELA statute of limitations. Failing to file your FELA claim within the required 3-year statute of limitations can have serious, irreversible consequences. Courts strictly enforce the filing deadline, and claims submitted after the statute expires are almost always dismissed, regardless of how severe the injury or how clear the railroad employer's negligence may be. This means that if an injured railroad worker or their personal representative fails to act in time, they risk losing the right to pursue compensation altogether. The financial repercussions of missing the deadline can be devastating. Injured workers and their families may be left to bear the burden of medical expenses, lost earnings, long-term care costs, and other financial obligations without legal recourse. This is particularly damaging in cases involving occupational diseases like cancer, where treatment is expensive and ongoing. Delaying legal action can also compromise the strength of your case. As time passes, crucial evidence may be lost. Equipment may be replaced or discarded. Accident scenes may change, and witnesses' memories may fade. Without strong supporting documentation and testimony, even a valid claim can become difficult to prove. Although there are some limited exceptions to the statute of limitations, such as cases involving fraud, mental incapacity, or the discovery rule for latent illnesses, courts grant these exceptions rarely and only under strict conditions. Most FELA claims must be filed within 3 years of the injury or reasonable discovery of the illness. Here are the essential steps for filing a FELA claim in time. 1. Seek immediate medical treatment and document your injuries clearly. 2. Notify your employer that you were injured while employed in the railroad industry. 3. Consult an FELA attorney to determine whether a safety statute was violated or if your employer may be liable. 4. Gather and preserve evidence, including incident reports, medical records, witness statements, and photographs of the job site or equipment. 5. File the claim in state or federal court before the 3-year statute of limitations expires. 6. Negotiate or prepare for trial, depending on whether the railroad company offers a fair settlement. 7. Pursue full compensation, including lost wages, pain and suffering, and any future losses stemming from the injury. Do you qualify for a FELA lawsuit? To qualify for an FELA lawsuit, you must be a railroad employee who was injured while working for a railroad engaged in interstate commerce. The injury must have occurred while you were acting within the scope of your employment, whether on a moving train, in a rail yard, or performing job duties elsewhere. Unlike workers' compensation, FELA requires you to prove that your employer's negligence played a role, no matter how small, in causing your injury. This could include a failure to provide proper safety equipment, violations of a safety statute, or unsafe working conditions. Occupational illnesses, such as cancers linked to diesel exhaust or asbestos exposure, may also qualify if they stem from work-related exposures. FELA also covers repetitive stress injuries and cumulative trauma that develop over time. If a railroad worker is killed on the job, the personal representative of the estate may file a wrongful death claim on behalf of the family. Speaking with an FELA attorney is the most effective way to determine your eligibility and begin building a case. Gianaris Trial Lawyers, experienced FELA attorneys. At Gianaris Trial Lawyers, we understand the physical, emotional, and financial toll that workplace injuries take on railroad workers and their families. Our legal team has extensive experience handling FELA claims and a proven track record of holding railroad employers accountable for unsafe conditions, negligence, and regulatory violations. Whether you're dealing with a sudden injury, long-term illness from toxic exposure, or the loss of a loved one, we are prepared to fight for the full compensation you are entitled to under federal law. Don't leave your future in the hands of the railroad's claim agents. Get trusted, trial-tested legal representation. Contact Gianaris Trial Lawyers today for a free consultation. Use the chatbot on our website, lawforpeople.com, to find out if you qualify for an FELA claim immediately.